turn to the fourth case on this morning's docket, case number 118235, State of Kansas v. Anthony Raymond Becker.
May it please the Court, Patrick Dunn, Deputy Appellate Defender, here today on behalf of Anthony Becker. May I please have 3 minutes for rebuttal?
3 minutes is granted.
A jury convicted Mr. Becker of a single count of premeditated first-degree murder, and this is his direct appeal. I anticipate submitting issues 6 and 7 for sure on the brief, along with any other issues that we don't discuss today. And I'm likely going to combine some of the issues on the lesser included offense instructions, assuming we have time to reach those today, too. The issue I want to focus most upon is the first issue in Mr. Becker's brief, which is the allegation of prosecutorial error. During the state's rebuttal portion of its closing argument, and I think also, as we know, rebuttal is different than the opening in that there is no time for defense counsel to respond to it. And this was right at pretty close to being out of the gate. The prosecutor made statements that it does not matter what happened to James Schmidt or Chelsea Sosa as far as their charges in this case. Then states, during voir dire, you remember I asked you if you'd be able to consider this case without considering what happened or what was going to happen to Sosa and Schmidt. Now you'll need to remember that. And then he concludes by saying what happened to what they pled to or didn't plead to, that is not part of the case. Now the problem with that, of course, is that is completely part and parcel of this case and was crucial to the defense in this case. The defense in this case that Mr. Becker asserted was that he was not the shooter. He was actually had confessed to the shooting to cover up for Miss Sosa. This case is really a sad story of kind of almost a love square, and what happens when methamphetamine is intersected with that. In any event, by stating these two individuals, Mr. Schmidt and Miss Sosa, got basically the deal of a lifetime. Originally charged with premeditated first-degree murder, conspiracy to commit premeditated first-degree murder, and there were also aggravated battery charges. These people ended up walking away with probation. Miss Sosa herself didn't even have to actually serve probation. She received time served, never served any probation whatsoever. So they had a powerful incentive to testify in a certain way, specifically that Mr. Becker was the shooter in this case. In analyzing prosecutorial error, first we determine whether or not the comments fall outside the wide latitude allowed to prosecutors, and second, whether it offends, if that occurs, whether or not that offends the defendant's constitutional right to a fair trial. And then if the error is found, the state must demonstrate beyond a reasonable doubt that the error complained of did not affect the outcome in light of the entire record. Here, I think it's pretty clear that the prosecutor misstated the law. A plea deal is always admissible to show bias and as impeachment evidence, and we cited several cases about how it's crucial evidence at trial. By saying that it's not part of the trial, it certainly was misstating the law, and that it was absolutely part of the trial in this case. In fact, it was the state who brought up the plea deals during direct examination of both Sosa and Schmidt. It wasn't defense counsel and Cross that brought that up. So the state knew it had to deal with these things. This was very important evidence, and the state had to do something about it. Now, on appeal, the state claims that the prosecutor was merely pointing out that the plea deals did nothing to undermine the strength of the case in light of the state's evidence against Mr. Becker. However, that strength was based upon Mr. Becker's confession, and the whole purpose of the prosecutor's statements was rebutting what defense counsel had just articulated as the defense in this case. It was, I believe, a third and fourth page into the rebuttal argument, pretty close to being right out of the gate. Defense counsel had just argued that the confession was his attempt, and apparently now successful, to protect Sosa, whom he still loved, from prosecution as the true murderer, and that she had acted out of anger because her boyfriend, Mr. Boyd, desired to pimp her out to satisfy his own meth habit. So when you look at it in that context, this wasn't just saying, oh, you have to look at all this evidence. This was trying to counter the theory of defense in this case. With respect to harmlessness, the state claims this is just harmless error, and it relies pretty much wholly upon Mr. Becker's confession. But again, the theory of defense was that Mr. Becker confessed to cover up for the woman he loved. And if you watch the confession, which is not that long in this case, and it's in the record, you can hear him still say that he still loved, even after all this happened, still loved Miss Sosa. And even if she probably did not love him. And I think this was even after, and I may be mixed up on this, even after he had asked to speak with her, and she said, and the officers, to their credit, went, because she and Mr. Schmidt were in other interview rooms, and they went to go talk to her, and she said, no, I don't want to talk to him. So even after that, still loved her, still kept with this story. As pointed out in closing by defense counsel, there were Mr. Becker, this was a strange, I guess, love square again. While he was engaged to Miss Sosa, Mr. Schmidt started dating her. It was questionable whether Mr. Schmidt was ever engaged to her or not. Miss Sosa said they never were. He said, I thought we were. Not quite sure what happened there, but while that was going on, that's when Mr. Boyd comes into the picture. But what's important is Mr. Becker still spent time socializing, hanging out with, whatever you want to call it, with Mr. Schmidt at the time that he came and stole his love. Likewise, there was Mr. Boyd in the initial, up until his death, there was never any evidence that Mr. Becker had acted on anything at this point in time. In fact, it's kind of unclear completely from the evidence, but it seems like there was some sort of, Mr. Schmidt was the one that wanted to actually beat up Mr. Boyd, and that kind of comes through a little bit in Mr. Becker's statements to the police. But in any event, the point being that Mr. Becker had been spurned already twice and done nothing, yet the triggering event, the catalyst, if you will, when all this happened was when Mr. Boyd pushes Miss Sosa to go prostitute herself at the Flying J in Dodge City so he can have more meth. So when we look at that in that light, that tends to push things again towards Miss Sosa. My point being, it's the jury's job to weigh this out and decide this. This court's not an evidentiary court. It's the job of the jury to decide this. And our point is, had the state not made these statements, there is a real possibility, or the state cannot show that there is a real possibility that they might have reached a different verdict. So with that in mind, we think that this court should reverse and remand the case for a new trial. The next couple of issues deal with the district court's failure.
Excuse me, just so I understand, you're not claiming that the confessions and the letter that he wrote, which is another confession to the family, that those were not freely and voluntarily made. You're just claiming that they were made for an ulterior motive to protect.
Yeah, I think it sounds, though our cases are notably different from the case just prior, but people have different reasons for making statements. We know that confessions are not always accurate, nor would a written statement necessarily be accurate, particularly if he's trying to cover up for Miss Sosa. It makes sense. They asked it because the KBI agents asked him, would you be willing to write an apology letter to the grandparents? And he said, yes, and he writes the letter. That's completely consistent with him wanting to cover up for Ms. Sosa. What's strange is if Ms. Sosa didn't do anything, why did she write an apology letter also? It didn't seem to make a whole lot of sense to me, and I believe this was also argued in defense counsel's closing, why she wrote an apology letter. If she didn't have anything to do with this, she was just an innocent bystander who was scared of everything.
Well, no, she apologized because she said that she lied to them and didn't call the police after this happened. So she explained why she was apologizing.
She mentioned that, but she also then goes on to say, I understand if you hate me and despise me forever, which I'm not really sure why you would hate someone just because they didn't call the police that specific day.
Well,
It doesn't seem to me to be a letter consistent with someone who is terrified of this whole situation. But in any event,
But my point was that while there's a pretrial hearing on the admissibility of the confession, and that was ruled against you by the district court, you're not challenging that on appeal.
okay, I think what you're asking is whether or not I'm arguing that it's involuntary. And no, we're not. It wasn't raised. The issue wasn't raised in terms of the voluntariness of the statements.
It's voluntary but false,
Yes.
is your position.
Yes. We weren't. The issue wasn't raised in those terms. Am I on the same page with you
Yes,
there?
yes.
Okay. I guess actually, I'm looking at my time. I wanted to briefly mention something about voluntary intoxication before moving back to the lesser included offense instructions. It's largely fact-based things that I wanted to point out. The district court largely relied on the fact that Mr. Becker's confession had a recollection of the event. And it cited back to the Hernandez case and another one that escapes me at the moment. But this case definitely centered around meth. There's no question, I think, that Sosa, Becker, and Mr. Becker and Mr. Boyd all were high the night of the shooting. Sosa said she'd been up for days at that time. Given that they spent the day riding around Dodge City smoking meth that day, I think a jury could reasonably assume that Mr. Becker likewise had been up for several days. And when you take into conjunction Ms. Sosa's testimony when asked about Mr. Becker, that he, quote, looked possessed almost, that wasn't Tony, that evidence right there could have been enough for the intoxication to be that he wasn't consciously making his own decisions at that point in time. And the reason I want to bring that up is I don't think that necessarily someone who doesn't recall what happened, that does recall what happened, means that they had full control of their faculties. I think that's kind of a false equation. Just because you remember something doesn't mean you were fully in control and having a conscious decision-making process. So that was all I wanted to bring up about that, but I wanted to be sure that point was raised with respect to voluntary intoxication.
So your evidence of impairment is just the ingestion, which is consumption evidence. You're kind of equating the consumption and the impairment?
Not just the consumption. Miss Sosa.
Per description.
Yeah,
Other
that
than
he
that,
looked possessed.
Do you have anything
That
else?
wasn't Tony. That wasn't Tony, I think, is one of the most telling aspects.
Do you have anything other than that statement?
That's mostly what I have, other than the obvious evidence that there was an extreme amount of consumption. But I'm just pointing out that it's more than just consumption in this case. Her testimony is that he didn't look right, he looked possessed, and that wasn't him. My time's expired. I could take a minute into my rebuttal if you wanted me to talk about the lesser included instructions, or I could go ahead and submit those on the brief, whichever the court would prefer.
I was going to ask, your choices are to sit down now or to take 30 to 45 seconds to kind of wrap up what you've told us so far, if you feel you need to.
I think I've covered what I wanted to on the first two. And just with respect to, I think, if the state brings something up, if they want to talk about the lessers on second degree and voluntary manslaughter, I can respond to those. But otherwise, I think they're adequately briefed, and I'd submit those on the brief.
Very well. Do we have any further questions? Thank you, counsel.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. Regarding the prosecutorial error, it would be the state's position, although I think this court kind of rejected it in Boothby, which you issued on Friday, that the error, because there was no objection, it should be the defendant's burden to prove that the error was reversible, not the state's. This would have been a really easily cured error if he had objected and said, this is what we understand the prosecutor's statement going to, that's an improper statement if you're basing it on credibility. I don't think that's what the prosecutor was attempting to do here, but had that been pointed out, the prosecutor could have then explained what he was doing. But turning to the merits, the prosecutor's point, as I read it anyway, was that the confession itself was all the evidence the prosecution needed here. It didn't need, the fact that there was leniency given to Soso and Schmidt didn't undermine the state's case in any way, shape, or form. If it's read in that light, I don't think the statement is error. If it is read in the light that the credibility is not an issue, which I still don't think that was the prosecutor's intent, then it was error, but it was harmless. Again, the statements can be construed as having a proper purpose. Becker's confession really was sufficient in this case. Not only did he confessed in great detail, and those details corroborated the physical evidence in this case. The jury instructions here would have mitigated any error. They told the jury that they could have weighed, that it was their duty to weigh the evidence and the witness's credibility. And again, Becker's confession in this case is overwhelming evidence. It was the strength of the evidence, not any misstatement by the prosecutor, that led to the conviction in this case. I would like to briefly touch upon the lessers, not in great detail, but it's basically the state's position on the lessers that we agree with Justice Rosen that the test is not a sufficiency of the evidence test. It's whether there is some evidence that would reasonably justify convictions of the lesser. If this court wants to tell the state and lower courts in very clear terms that every time there is premeditated first-degree murder, there has to be a intentional second-degree murder, please just do it, and then we don't have to have those arguments anymore. However, even if a lesser should have been given in this case, and I don't think the lesser should have been given on voluntary manslaughter for all the reasons that are in my brief, again, the error was harmless. There's overwhelming evidence of premeditation in this case. There's a lie to lure Becker into the shed. He grabs a gun, he conceals it. He walks a very long distance through a very narrow part of the shed too and leads him where he wants him to go. He then shoots him in the back the first time, empties the entire gun, which is apparently about 10 shots if I'm remembering correctly. He hits him 6 times, and then he stomps on his head just to ensure he's dead. I don't know that it is a very strong case of premeditation. Any error here, the jury just simply wouldn't have gone to any lesser. As to the voluntary intoxication, I would briefly point out that the argument raised by counsel today was not in the brief regarding the statement that he looked possessed. I didn't see that in the brief. But regardless, the only evidence here was of mere consumption, and that isn't sufficient to give that instruction.
Didn't the trial court make findings at sentencing, though, in terms of weighing departure factors? That
Correct.
the defendant, this played into that, and with that finding, doesn't that undercut your position?
I think those are two very separate findings. First of all, that finding doesn't overrule any of the cases on what you need in order to get a voluntary intoxication instruction. A voluntary intoxication instruction requires more than mere consumption. It requires the fact that he could so clearly remember exactly what happened in his confession would have undercut that. I think the case law says no instructions given here. The fact that at departure the district court chose to show leniency is an entirely different question on whether or not that instruction was legally required.
More than leniency, the judge made a finding that the defendant wasn't in complete control, that went to the culpability of the crime, and he made that finding based upon the intoxication, didn't he?
He did it based on the meth usage, but I still don't think those are the same thing. And I think the district court judge might have made a mistake at sentencing is another way to view that, just because, but we're not challenging that. We didn't cross appeal or anything like that. But that doesn't undercut the fact that as a matter of this court's precedent, what happened in this case does not warrant a voluntary intoxication instruction.
What's your,
Evidence that came in. I mean, that's what matters. is
Yes.
What came in on evidence of impairment. And
Yes.
your colleague has just said the only thing is her statement about him looking
Correct.
possessed and not himself.
Yes, and that has never been enough. I think that's just a red herring. Whatever happened at sentencing,
Was there additional evidence sponsored at sentencing about his level of impairment on the day of the crime?
I don't believe so, but I am not sure. I think the judge has a choice between a hard 50 and a hard 25, and he felt a hard 25 was more warranted in this case. That's a decision the state didn't challenge, but I don't think it undermines all of this court's case law on why voluntary intoxication is not a required defense in this case. And the district court judge made findings at the time when the voluntary intoxication instruction was requested on why it wasn't then. But to the extent this court somehow determines there was an error, again, harmless, overwhelming evidence, and that confession shows he remembered what he was doing, and no jury would have changed their verdict. I would like to talk about the illegal sentence briefly. I did a 609 letter in this case. Originally in my brief, I conceded that it should be vacated and remanded for resentencing. I do agree that the sentence is illegal. He should have gotten parole instead of lifetime post-release. But this court recently in Johnson and then also in Ballou, which was issued on Friday, and I did ask defense counsel, he said it was okay if I mentioned Ballou. He has read Friday's cases as well. Did say that remand isn't required, so I would argue now that maybe no remand is necessary, or this court could clarify when a remand is necessary versus when you can just vacate and have no resentencing. That is all I have, unless there are any additional questions.
So your position is we can simply vacate that.
Yes, Your Honor.
Any more questions? Thank you, counsel.
Thank you.
As always, at my peril. The first thing I wanted just to mention, since the state had mentioned it wasn't in my brief, I didn't write the brief. However, I wanted to provide the site to to Ms. Sosa's testimony that he was possessed. That was on volume 23, page 42. Just because it wasn't in the brief and there was no site. I just wanted to be sure there was a site. I think with respect to the lesser included offenses, one of the biggest problems I would regularly argue about, and I think with these, is that we are taking this away from the jury, who is supposed to be the fact finder. I understand that when you don't just throw any crime out there, but when the crimes are actually lesser included offenses, the jury should be the one to decide. I don't understand why when under the existing case law, it is a legally appropriate instruction, it's factually appropriate, that we're going to go ahead and take it away, why we would have a mistrust of juries not to make the right decision. And I don't think we should be taking these things away. If it is so obvious and so harmless, then on retrial, it will come back as a premeditated first-degree murder. But we should not be taking these lesser included offenses away from the jury.
Just so I understand what you're saying if it's legally appropriate and factually appropriate, but who makes that? The threshold issue is whether you instruct, and who else can make that factually appropriate finding except the trial judge?
I'm with you on that. But when we talk about factually appropriate, it's whether there was sufficient evidence. It's basically the reverse sufficiency test. It's not whether I think the evidence can only show premeditation, but we know premeditated murder, it's kind of, I think the state pointed it out in their brief. If you have a first-degree murder, you always have all the elements of second-degree murder. It's always factually sufficient.
So you're saying just skip the next step?
With respect, explicitly with second-degree murder, it seems like under this court's law, unless you move to where the district court weighs the evidence in its own mind there, then yes, it should come in every case.
First degree pre-med.
And it's a limited circumstance because it's not the same circumstance with respect to voluntary manslaughter. There's different elements involved. It's legally, as our case law says, legally a lesser included offense, though it doesn't have the same identity of elements. But in this case, we also, I mean, if we go through, this was actually, I'm not ordinarily always up here able to say, there were objections. These were requested instructions. That's the first step under the instructional analysis. Were they requested? Second, were they legally appropriate? No question, all of them were. Was it factually appropriate? I explained second degree. With respect to voluntary manslaughter, we don't know exactly what happened in the shed. We do know, however, as counsel pointed out, there had never been a problem, even though Mr. Becker had been the jilted one on at least 2 prior occasions. The catalyst here was Mr. Boyd deciding to go pimp Miss Sosa out. I think that's something that a juror could understand, might push someone into a heat of passion type situation.
The confession by your client.
Again, I pointed out covering for her or
Right, I
as the
understand.
jilted lover situation there. I mean,
I understand that's the theory of the case, but it didn't mention that there was further argument or discussion of this suggestion of prostitution while in the shed, did it?
we don't know what happened in the shed. He didn't.
Did he mention it in his
Not in the
statements?
confession, he did not. But we don't know exactly what happened. Frankly, it doesn't make a lot of sense. And it was not directly in the brief. According to what Miss Sosa said, they are all up in his bedroom, which is the upstairs of the Becker house. He being Mr. Becker and Mr. Boyd go downstairs and go out to the shed. But they're walking together. It doesn't make a lot of sense to me how, I got to make a stop over here to this buffet to get this gun. That doesn't make a lot of sense to me there, how Mr. Boyd wouldn't have noticed that. Nevertheless, they go and they walk out there. We don't know exactly what happened. There's a lot of kind of missing pieces there. And it's our contention that the jury should be the one to be able to sort this out. And they might very well have decided this was a heat of passion situation.
So as long as there's the reverse sufficiency test, as you refer to it, in making the factual determination, really every lesser in nearly every first-degree murder case has to be given.
No.
Why
at all.
not? Why not? Well,
Well,
like here,
there's-
why is voluntary precluded here? I mean, didn't you
Involuntary,
make
you
it?
mean?
No, didn't you said there's not the same elements, but isn't there evidence of some sort of heat of passion based upon?
Yes.
Yeah, so that
In this particular case,
Right.
that's the facts of this case. But in another case, if we had no evidence of these pre-existing relationships or anything like that, if it was just somebody out there, we have no possible explanation, then there's no facts that could bring up.
But it would be your position that second-degree intentional always has to be given.
Yes, I think that's the argument.
Based on our reverse sufficiency.
Exactly. If we're going by reverse sufficiency, then logically it's all, and that's what we look at is whether the facts are present. Under that test, the facts are always present. And it's up to the jury at that point whether or not they think there's premeditation.
Any further presentation? All right, any further questions? All right, thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.